Administrative Committee is dated 27/2/2017. Which was approved by the full court on 6/3/2017. The final list came on 6/3/2017 on the same day. Now I have got 4 points. I will not take more than 10 minutes.
Just 1 second. Should we finish with the finish now? Of appointment issued?
I have been working
because there are no interim order
from
2017.
So pretty much, I think they must have been appointed by the governor after the consultation with the governor consults the High Court.
2017, as per the final list, those were appointed and they are continuing in service.
1 year service in the 1 year training in the Judicial Academy in first year. Then they are posted.
You can't disturb posting.
So now your clients are out all these years.
Out all these years.
Now those people are already in since 2017.
I scored high in the return time.
Now, Mr. Chidambaresh, the only problem,
6 years.
6 years, these chaps have been working now in the district judges, as in the judiciary, right? These are recruitment to civil judge, junior division. District judge.
My anxiety is only this.
This is a lateral entry to the district judges.
I know it will be difficult to displace them now. I know. But the problem is this. One among the petitioners is doing exceptionally well at the bar. Her chances of being elevated to the bench will be affected because the allegation is you did not pass the district judge selection.
is, prima facie, what is, of course, we'll hear the High Court lawyer. Who's appearing for the Kerala High Court? Jose, no?
Sheshadri Naidu, who said he wants to.
Sheshadri is appearing. Oh, yes. Jo- all right, no problem.
You can ask.
Now, Mr. Chidambaresh, assuming that you are right, this issue of change of the rules midway, strictly speaking, is a subsidiary issue. Yes, they did change the rules midway because it was after the Viva Voce was conducted that they introduced this minimum cutoff for the Viva as in terms similar as the written exam. But more important in this case is the fact that the minimum cutoff which they imposed for the Viva was directly contrary to the rule 2C3.
Scheme of examination also stipulates that.
Now,
Kindly,
Mr. Chidambaresh, having said that, we just look at the scheme of examination in a minute. So really speaking, the reference may not arise in this matter. Two, if you are right, subject to hearing Sheshadri, if you are right, the decision of the High Court to introduce a minimum cutoff was contrary to Rule 2C3. But third, coming to the grant of relief, at the end of 6 years now, when these people are working, we may not be inclined to disturb those who are already working. What we could do is this. We will say that many of your clients would have now joined the bar. Probably all of 4 of them have joined the bar. If they are good, they may even aspire to becoming High Court judges in future. We will clarify that our decision not to grant you relief has no bearing on your intrinsic merits. And therefore, the fact that you did not ultimately qualify in this examination will not affect your future prospects in any other selection.
Exactly. That is my apprehension also.
For all we know, any of you may become High Court judges tomorrow.
Hopefully.
Yes, we've had High Court district judges who resigned, joined the bar, and then became High Court judges.
Yes.
How many in this batch of 4 matters? No, there are only how many petitioners are there?
10.
They are here before us. But everybody is served.
My lords, in fact, in 215, although it appears for the Gujarat High Court.
One second. But the fact that our 9, 11, and 12 would have ranked below you in the aggregate marks, that's what you're saying, much below. But the fact still remains that now they've been working as district judges for the last 7 years. Many of them would be now virtually coming on the threshold of becoming High Court judges,
Whereas you would have joined the bar or seen something else, because 6 years wouldn't have gone by without.
All right, look at it from your point of view. Suppose we appoint you as district judges today, or we say that you should be appointed. We can't give you seniority of 2017. Your seniority will come today. But I know they are okay because today this is such a valuable employment under the state. But the point is that, now to displace people who are working, after all, they've worked as district judges for.
There's another issue. There is a human problem involved, my lords. 6 years they are expecting, and the practice also.
We understand that.
My lords, side by side.
Dinesh, you're absolutely right. No doubt about it.
Just for any lawyers.
We are completely with you on that. But now we have to look at both sides. You have on the other hand, people who are working as district judges for 6 years now to tell them you go home. And after working you tell me to join the bar today, I don't know what will happen to me, because if I don't think I can answer questions of judges as Brother Narasimha was answering until recently.
Narasimha is the only exception.
How will these people even go back to the bar after having been judges for 7 years? It's very difficult to go back to the bar and start a new career.
If it were a selection which is arising immediately thereafter, perhaps we would have asked the High Court to give them some kind of a concession or relaxation and take them in. But then this period of 6 years is something we can't tell the High Court to, in the next selection, give a priority or some kind of.
6 years is too long.
No, but then after 16.
Yeah, that would be an unfair thing to
outside.
accommodate them now. You lose seniority in so many things. I mean, in service. You see, I was just telling the Honorable Chief Justice, for all you know, this decision of the administrative committee might facilitate those who are in practice to come into the bench of the High Court faster than these people who have been selected as district judge. Possible. No, one is just saying, I mean, to upset those who are already working.
Mr. Natraj, you are appearing, you are the one person who is disconnected from the matter in the sense that you are appearing as law officer.
Yes.
What is to be done? You've been hearing the facts.
Some of the persons, if still they are interested, without disturbing them, they can be accommodated at least in the coming this one. Because already they have.
Also, how do we do that, Mr.
And we have already held that it can't be done because
Because
there are
subsequent
future
selections,
prospects of
if,
the younger generation which is now ready.
3 vacancies will be taken away from a future selection, for which there would be people who are willing to apply today.
Unduly,
They were not qualified.
they are denied. It's one thing.
My Lordship, may only say on behalf of petition number 4, my Lordship, in this particular same set of Kerala matters, petition number 4, my Lordship, she is not only a widow. The challenge is that, my Lordship, she belongs to OBC PR community. Now, what has happened, my Lordship, the process is now brought to the fore. A new group of people out of which there's not a single person in the SC/ST community, from the OBC community, or from the communal reservation as per the number of Muslims as well. Now, what has happened, my Lordship, is there's an entire under-inclusion which is coming through with this. And here
We leave it to the High Court. Leave it to the High Court and then do it. You can't get
all these people may have had an opportunity to Viva. My Lordship is right. The aggregate question of whether the marks been taken together, inclusive of the Viva and the written, my Lordship, yes, there is an aggregation there. But the challenge here is, my Lordship, what has now happened in the process, the consequence which has now come in, my Lordship, is that some of the more worthier candidates today stand eliminated entirely. And
You are eliminated.
to the extent, my Lordship, today what is happening is, my Lordship is right, coming to the bar. Now, what happened is, my Lordship, last occasion when matter before my Lordship, before Justice Banerjee, when the matter should have been resolved. What has happened is, my Lordship, the matter has been.
Right, it's been pending for, had we taken up this matter when the reference was made, we would have said, all right, they have no equities, they were just come in 1 year ago.
My Lordship,
See the judicial process, yeah.
My Lordship is rightly mindful of the other persons who've gone in on the bench, but my Lordship, consideration of these candidates.
2018, 18 maybe they could have allowed the petition, you know.
That time it would have been.
If the petition was allowed in 2018, it may have been much more equitable because, you know, these people had just joined in 2017. I mean, there was no equity in their favor. But now by the pendency of this reference for 5 years, Mr. Sheshadri, is he online? Shraddha, who are you appearing for?
My lords, I'm appearing in the petition for the Gujarat High Court, and the scenario in our case is, my lords, that there were 219 posts that were advertised.
A little later. We'll deal with this. We are not dealing with this on issues.
My lords, the only reason I wanted to state is because in our case, this was 2022, and there are in fact 160 posts that are still lying vacant because only 55 candidates out of 219 posts have been selected. And in fact, my lords, the total mark secured by my clients is far higher than the marks secured by the persons who have been selected. For example, my lords, petitioner number 2 in my case, in the written test alone, secured 142 marks, which is what rank 23 has secured.
You are in the same team as Mr. Chidambaresh, Mr. P.V. Dinesh, but perhaps you are saying your marks are even better than...
Even higher, my lords. Even in rank, if the cumulative score would have been taken, I would have been in the merit list of top 10 candidates.
2022. You are 2022.
Yes, my lords.
So it's just one year back.
Yes, my lords. And in fact, there are only
you're right.
55.
We will deal with your case separately. We'll complete this. Now we'll hear Mr. Naidu. I think Mr. Naidu is online.
Is he online? So Jose, Ramesh, is he there? Okay, can you tell us?
Find out.
Dama Sheshadri Naidu.
You can दिखा है क्या? नमस्कार
नहीं.
Just send message.
Alright, we'll ask Naidu. We'll ask Naidu.
So far as accommodating is concerned, considering the facts and circumstances, take a decision on how to accommodate them with sympathetic.
Just check whether yes, anybody is interested.
Review. And do it
वो जरा
informally,
check
we'll
करने
tell
को
them.
बोल दो ना नायडू को phone करके. If anybody has Mr. Naidu's phone, just give him a call and say that he can join. We are waiting for him. Huh? All right. चलो खत्म कर देंगे. अभी dictate कर ही देंगे. We are not interfering. I don't have to be.
Whatever future
Exactly.
dates, है ना?
Trying to join through court, Mr. Naidu is trying to join through. He's connected through court.
Reference order of Bhanumati. हो जाएगा वो 2000. I'll get it in.
Trying to join.
Bhanumati would have referred it in 2018. No?
Trying to join.
So you see, so I don't have to go. Which would. Saint Joseph and Bhanumati. No? Judgment reserve.
Yes, yes, yes.
2nd November, 14 November. Yes, I got it.
In the meantime, can I point out two other provisions in the scheme?
You wanted to show us the scheme, right?
Yes.
Yeah, no, we'll just see the scheme. Huh?
But in the
What page is the scheme?
It is 501.7.
No, the scheme will be there in Dinesh's compilation also.
In, not the, in 501.7 paper book,
Yes.
it starts at page 26. 25. PDF page number 33.
501.7.
501 point. Yes.
Should be 62. 62.
Scheme of examination as amended by the full court minutes dated 13/12/2012. Cut-off mark. The candidate need not secure any separate minimum marks for each paper. The general candidates who secure 50% and SC/ST candidates who secure 40% aggregate minimum for both the papers shall be declared as qualified for the Viva OC examination. Then, further down below, written examination. The Kerala Higher Judicial Service examination will have a written examination for two papers carrying 150 marks each and a Viva OC carrying 50 marks. Then,
Yes.
further
My lords,
down-
can I be heard?
Further
Yes,
down,
Mr. Naidu, just 1 minute. We'll come to you in a moment.
further down below, with regard to Viva
My lords,
OC.
Just 1 second. Secretary, 1 second. Yes. Where is it at? Where is the reference to Viva? Yes, at page 28 bottom. That is page 65 bottom.
The Viva OC test should be in a thorough and scientific manner, and it should be taken anything between 25 and 30 minutes for each candidate. There shall be no cut-off marks for the Viva OC. Explicit in black and white. There shall be no cut-off marks for the Viva OC, which was not pointed out before your lordships earlier. Viva OC shall be conducted by a board of honorable judge constituted for that purpose. The merit list will be prepared on the basis of marks obtained both in the written examination and Viva OC. Then, your lordship will get the notification.
3915.
The notification starts at?
Next page, 31.
Yes. Mode of selection. At page 32 deals with the mode of selection. Then at page 33, if the number of applicants the merit list, page 33 begins like this. The merit list of successful candidates will be prepared on the basis of total marks obtained in the written examination and Viva OC.
Where is that?
33 at the top.
If the number of
Yes.
applicants.
If the number of applicants is disproportionately large vis-a-vis the number of posts to be filled up, the High Court reserves the right to shortlist the candidates by their length of practice at the bar. And such shortlisted candidates alone will be called for the written examination. The power to shortlist is there, but only on one contingency, only on one criteria, depending on their length of service, nothing else, not on the basis of marks in the Viva OC.
And this has not been varied.
And this has not been varied.
Nor the scheme.
Nor the scheme.
Perhaps there is actually variation.
It is a variation. Because that was approved by the AC, by the full.
This is also wrong because application use.
Will kindly see the language of the minutes of the full court, or minutes of the administrative committee. That is at page 46. 46. Paragraph 2. The administrative committee meticulously examined the marks awarded to each candidate in the Viva OC by the members of the selection committee under the above 6 different heads. After such examination, the committee is satisfied that the prime consideration of the selection committee while awarding marks in the Viva OC was the suitability of candidates to man the notified post. It is the ultimate object of a Viva OC to weed out incompetent and unsuitable persons who may squeeze into the service by mugging up answers in a written examination. This elevation to the bench, squeezing into the service. The Katanoff decisions of the Apex Court also lays down the above salutary principle. So the committee is of the firm view that the stipulation of 50%, 40% marks respectively for the general and SC/ST candidates in clause 5 of the notification in the present selection and similar clauses in the other notification for which the common examination was conducted is essentially applicable to the Viva OC examination also. Then towards the middle of the next paragraph. The split up of marks under the 6 different categories. 6 different categories are knowledge, skills, attitude, ethics, communication, character. The split up of marks under the 6 different categories will indicate that 30 out of the total 50 marks is for the first 2 categories, which are of permanent importance for a judicial officer in the cadre of a district judge. The candidates who had obtained less than 50% marks in the Viva OC had fared very badly in the above 2 categories, and whatever little marks they had obtained are mainly under the remaining 4 less important heads. And therefore, the committee is of the firm view that they are not suitable to man the post to which the recruitment is carried out. Recruiting such persons will be disservice to the public at large, which was not the intention of the full court. The beginning of the minutes also para 1. The administrative committee previous speech, the administrative committee considered the marks secured by the candidate in the Viva OC examination. Though in the scheme approved by the full court on 13/12/2012, it is stipulated that there shall be no cut-off marks for the Viva OC. It is not an empty formality. Viva OC is expected to be conducted in a thorough and scientific manner. Each candidate has to be interviewed for 25 to 30 minutes, 6 different heads under which the heads marks are to be awarded, and the maximum marks that can be awarded under these heads are also stipulated. So it is clear that certain minimum standards are expected from the candidates, without which they cannot be found suitable for the above post.
Mr. Naidu? Thank you, Mr. Chidambaram.
Yes, my apologies. And it's nothing short of foolhardiness and audacity on my part being absent. I was away, Millets, because I thought my turn would be later.
You were in greener
extremely sorry.
pastures, Mr. Sheshadri. Yes,
Yes, Millets.
yes,
Millets.
Sheshadri, what you have to
It
say.
seems something fell from your lordship. That's what I was told, Millets. I gathered that without any stigmatic remarks, could they be dispensed with? Because, Millets, we took a conscious decision in the full court.
Sheshadri, we are inclined
Yes.
to take the view that the High Court decision is completely wrong. For the reason,
Millets.
first and foremost, that Rule 2C3 specifically says that the selection will be made on the basis of the aggregate marks, which are obtained in the written
Yes,
test and the Viva. Now, if
Yes.
that is applied,
Millets.
what you have basically done is that, forget the fact that the decision was taken midway through the selection process. We'll leave that aside for a moment.
Yes.
What you did was you said by the full court decision that the minimum cutoff which has been prescribed for the written exam shall also apply to the Viva. As a result of this,
Yes.
what happens is that those who get selected, actually, as a result of this, those who get eliminated
Yes.
on the ground that they have not got the minimum cutoff in the Viva would have made it if the selection was made on the basis of the aggregate of marks in the written examination and
Yes.
the Viva. In other words, what you have done is plainly contrary to Rule 2C3.
4 factors are clearly against you. First of all, it is contrary to the rule.
All things.
Number 2, the scheme specifically provided a distinct method which is to be followed, and cutoff mark was
Yes.
not permissible. Number 3, the notification said that if there are overwhelming numbers, then we will go only by the number of years in the bar. Number 4, this decision of the administrative committee is actually after the interviews were over. These are the 4 factors which
Yes.
give clear answer to the fact that the decision of the High Court is wrong.
Millets, only when we went to the hustings, we realized the practical difficulties and the impossibility of the process. I submit, Millets, it's true that the rule stares at us, but the problem is this, Millets, in the overall interest and efficacy of the adjudication at the lower levels, Millets, at the district level, we had to take this step consciously, all the full court unanimously. But the difficulty, I'll submit, Millets, the tendency has grown recently that most of the aspirants never attend the course, never practice. They go to coaching institutions, they get trained like automatons, and then they score very high in the written examination. When faced in the Viva voce interview, Millets, which is the vital part as to their practical knowledge, they have been
That is a
absolute
ground-
zero. And it started
that is
us.
a ground for
It
you to
started us.
modify your rule so as to provide for a cutoff specifically in the rule. Nobody's challenging the desirability of having a cutoff of a minimum marks in the Viva voce. But you must then specify it in your rule, which you have subsequently done in 2017.
But your notification said practice in the bar will be the.
Yeah. And you know, your scheme.
I reckon, Millets, when it comes to the appointment of the higher judiciary in the sense of district judges, it may not be an ordinary post, Millets.
Sheshadi, the scheme specifically says that the shortlisting
Yes,
will be made on the basis of the years of practice in the bar if the number of candidates is unusually large.
Specifically provided that the cutoff marks for interview is not permitted under the scheme. You have said it.
Millets, it's an exceptional decision under exceptional circumstances. only in the interest of efficacy at the district level, because they had all been young.
Should we do it now?
And
Right
with-
after lunch. We'll come. It's, we'll come back and dictate a short order after lunch in this matter. So 4 matters of Kerala will be over. Instead of starting now and come back after,
No big deal.
dictate it after lunch.
Great.